Good afternoon, everyone, and thank you for joining us today for this introduction to social media and defamation. My name is Amy Callahan-Page, and I'm an associate here at Anthony Collins in our dispute resolution team. I'm joined today by my colleague Neve Milross, who is a solicitor in our dispute resolution team as well.
Hi everyone, thank you for joining us today.
Today's agenda, we are firstly going to look at the rise of social media. We're going to look at the legal framework, which includes data protection, harassment, malicious falsehood and defamation. We'll look at some specific examples of these areas in the context of local authorities, and then there'll be time for questions at the end. So I'll pass over to Neve now to talk you through the rise of social media.
Brilliant, thank you so much, Amy. So we're just going to have a look at some statistics to give you a bit of an insight into how social media affects our everyday life, and also give you a bit of an understanding of your residents and how it's affecting them. So these statistics on this slide were collected between July 2019 and July 2020. As you can see, during that time, they found that more than half of the world's population is using social media, with an increase during that time of 136 million people. So that's a growth of 10.5%. Now this study was worldwide, so the figures may have been skewed a little bit by emerging countries who are slowly getting access to internet compared to Western countries who have had access to internet and social media for quite a long time, but also might have been skewed by coronavirus. So we know that the older generations are picking up social media much more than they would have in previous years, so they can keep in touch with their family and friends. But it still gives a really good indication of how social media is being used and rapidly picked up in different parts of the world. If you use your smartphone to access social media, you're in good company. There are 3.91 billion people that access their social media via their smartphone, so they can have instant access to news, updates, their friends and family. So it really does have a huge impact on everybody's life, and it is pretty unavoidable. So this slide just shows you some opportunities and challenges that we have thought would be relevant for local authorities when using social media. Social media can be brilliant. It can be used to increase your authority's presence and awareness. Generally, the younger generations aren't accessing their news in the traditional way, so via the newspaper or a news broadcast on the television. They are accessing their news and updates about their local area via social media. So if you can increase your awareness and your presence on social media, it will increase people's understanding of what your council is doing and how they can help you. Social media allows you to engage with your residents anywhere and everywhere, and allows them to engage with you anywhere and everywhere as well. Again, this is just broadening your presence, because it will mean that people will be able to have access to you, when traditionally this would mean they would have to come into a council building or arrange to meet their councillor at a designated time. Thirdly, social media access is increasingly expected in the electronic age. So many people expect to be able to contact organisations if they have any concerns, complaints, or just any questions. It can mean that they are expected to be contactable pretty much 24/7. But this is a good thing, as it again increases your presence and other people's awareness of your local authority and what you do. It can also be used as market research. So you can use social media to your benefit to analyse trends, analyse what your residents are interested in, what concerns them, where the council might want to be focusing, and if there's any sort of quick wins or long-term projects that the council want to be involved in. Now, obviously, social media comes with some challenges, and we're going to try and help with those today. So we've just made a list of a few problems that we thought you may face when using social media. As I've briefly explained, a lot of people expect social media to give access to organisations pretty much 24/7. It's certainly longer than the usual office hours that are normally applicable. Therefore, that means there will be a sufficient drain on resources if you need additional people or additional technology to manage that social media presence. A second challenge is that if you hold or host a page, for example on Facebook, you may then be responsible for what other people post on those pages. So it's not just what you as an organisation or individual are putting out there, you may be responsible for what other people are posting. Along with social media, there is a risk of how you process and collect data, and a risk to people's privacy being breached if that data is used inappropriately. And finally, a risk that we've flagged for you there is that an employee or a councillor's views, when posted on social media, may be interpreted by the wider public as being the view of the organisation or the council themselves. If this is a controversial view, it may cause embarrassment or confusion down the line, and therefore it's quite important that those views, when they're set out, are dissociated, which means that you specifically state that your view is your own and not the view of the council, just to avoid confusion or embarrassment later down the line. So now we'll move on to the legal framework, and I'll pass back over to Amy.
Thanks, Steve. Just by way of a bit of introduction, I thought it would be helpful to kind of explain the platform that we use for the different social media legislations and kind of the situation that we find we're all facing at the moment with social media issues. The legislation in this area has been very slow to develop, and the reality is that we have to apply existing legislation to new issues that perhaps weren't in the mind of the people drafting the legislation when it was first introduced. Last year, the Law Commission published a paper on harmful online communications offences and highlighted some issues in the current batch of legislation. And this therefore may suggest that changes are afoot in the future when this is looked into by Parliament in due course. There are three limbs to the types of legislation that we tend to see applicable to social media issues. The first is data protection, the second is harassment, and the third is malicious falsehood and defamation. Whilst malicious falsehood and malicious communications are different to defamation, there are some similarities there, so we tend to throw them in the same limb. And then Neve's going to talk about data protection in the first instance, so I'll pass back over to her.
Thank you, Amy. So the General Data Protection Regulation, or the GDPR, was brought into force in the UK via the Data Protection Act 2018. Now, as this has been in force for a few years, I'm sure you're all quite aware of it, and that it applies to emails, letters, or hard copy documents that you may hold, such as birth certificates or marriage certificates. But it's also important to remember that it also applies to social media and your interactions on social media. The Data Protection Act and GDPR places broad obligations on those who process and collect data, and the whole aim of it is to protect individuals who have their data collected and used. If you are collecting data, it must be used for lawful, fair and transparent reasons, and that when it's collected, it's used for specific, explicit purposes, and that it's only used for those reasons that you have been given consent for. So an example we've considered of how you might be using and collecting data on social media is, for example, if you run a Twitter poll, you might say, what do you think about this latest policy? Do you agree? Yes, no, why? If you collect that data and then use it for discussions in council meetings, that is how you are collecting the data on social media. You cannot then use that data you've collected for other reasons and apply it to other discussions or debates, as that's not why you collected it, and it would be outside of that limited scope. So as we mentioned earlier, if you are on, for example, Facebook and you host a page for the council, you may be considered to be the data controller as you are the page administrator. The data controller may also be Facebook, but those obligations may also fall on you or your organisation. Now, this issue came to light in 2018, where a German company posted a Facebook page which allowed people interested in their company to access the page, find out more, find out what products they had, and link through to their website. Facebook had placed cookies on the individuals' computers, which meant that Facebook could track how many times they accessed the page, when they accessed it, whether they purchased things once they moved through the page onto the website. However, neither Facebook nor the German company had actually told people who visited the site that these cookies were placed on their computers and that this information and data was being collected. The European Court of Justice found that that was a breach of people's data protection rights, and therefore Facebook were responsible for letting people know. But also, the German company were responsible because they were able to go onto Facebook, edit what cookies could be put on people's computers, and were responsible for alerting individuals to the fact that Facebook were collecting these cookies and these data. Therefore, it's important just to remember that if you're setting up Facebook pages or Twitter pages or other pages on social media, that depending on the settings, you may also be responsible for the collection of that data and be responsible as a data controller. If data is then used and used for purposes which are not permitted, or if the data is breached, then individuals who have suffered damage from that breach can bring a civil claim for compensation. We've had a few cases, both I and Amy have dealt with them, where people have had their data breached and have brought civil claims. We found that the claims tend to be small claims, but that in fact the money isn't the issue. We found that people who have had their data breached, it's the trust that has been broken down between themselves and the organisation, which is really key. And especially as local authorities, your relationships with your residents is vital. And therefore, if you do receive any claims or if there is any data breaches, it's important to recognise that it's not just the money involved, but it is that relationship breakdown that you need to manage. If there are data breaches, data subjects can also raise a complaint with the ICO, and the ICO can impose fines. So it's a bit of a two-pronged approach. You could receive a claim for civil damages and also a fine from the ICO. So it just emphasises how important it is to manage data correctly. So we've got a couple of suggestions for you that we've listed here, how you might manage data and put some things in place to help protect individuals and their data. So the first one is really to help safeguard against data hacking. On lots of social media pages, you can set up two-factor authentication, which means that when you log on, you need an email and password in the usual way. But you will have also given them, for example, a mobile phone number. Once you've logged on, they will ask for a specific code that they will now send to that mobile phone number. And you can only access the web page once that's been put in. So it just gives you an additional layer of security and gives you that confidence that only certain people who are permitted can, in theory, access the site. And like I said, hopefully will protect and safeguard against hacking. Our second suggestion is to make sure that everybody is aware of the privacy notices, that your privacy notices are kept up to date, and that if any residents or individuals you're engaging with on social media have any concerns about how their data is processed, then you can direct them to the privacy notices and, if necessary, engage with them, talk them through it. Our third suggestion is to make sure your policies and training for social media is kept up to date and is regularly reviewed. A couple of points with this one. So we found that a good way of ensuring that data isn't breached on social media is to have sort of pro forma example responses. So for example, it's a very menial example, but it's quite good to demonstrate how things can go wrong. So if I was a local councillor and Amy messaged me on Facebook and said, the potholes on my road are ridiculous and my car's getting destroyed, when are you going to sort it out? Me as the councillor, if I was trying to be helpful, I might look on the system, type in Amy's name, find out she lives on X road, go back onto social media and say, thanks for your question, Amy. I can see you live at X road. Our system says that we are resurfacing X road in 2 weeks. Hopefully your issue will be sorted then. While obviously I was only trying to help, giving Amy's address and name out like that is a clear data breach. And so including pro forma examples and responses in your policy and in your training might just avoid those circumstances, because then a counsellor or an employee will know to say, actually, in these circumstances, we refer you to this response, and they know where to find it. A second thing to consider about training and policies for social media is about making sure that people know when to take things off social media. So, for example, a lot of people use social media to complain about services or individuals. It's important to know when those complaints can be dealt with on social media and when they need to be taken off and directed through the appropriate channels so that they can be investigated fully and a proper response can be given. So again, training your staff and counsellors on when circumstances must be taken seriously and need to be taken off social media so that those processes can take place. And finally, subject access requests can be made by social media. They may not be as explicit as if somebody makes an access request via a letter or an email. And so again, linking in with the training your staff and employees and counsellors to know when those subject access requests are being made, who they might refer them to, and if there's any concerns about whether one has been made, referring it to the right people so that it can be dealt with efficiently and quickly. So I'll move on now to the second limb of our legal framework, which is the Protection from Harassment Act 1997. So Section 1 sets out what harassment is, and that is a person must not pursue a course of conduct that amounts to harassment of another individual, which they, as the perpetrator, ought to know amounts to harassment. A course of conduct is defined as at least 2 separate occasions for harassment to occur. Harassment is both a civil and a criminal offence. If you pursue the criminal route, then the individual may be imprisoned or subject to a fine. If you follow the civil route, then you may seek a civil injunction or damages against that person. But then there is a little bit of crossover, because if an individual breaches a civil injunction, you may then apply for a warrant for their arrest, because that breach is in itself a criminal offence. There's 2 sort of prongs and 2 different approaches that you may consider if someone is being harassed. So what amounts to harassment? Section 7 sets it out quite clearly and states that the individual committing the harassment or the perpetrator should know that their actions amount to harassment if a reasonable person in the possession of the same information, circumstances, would think that those actions amount to harassment. It's quite clear in the legislation that the conduct must be more than annoying or a bit irritating. It needs to cause alarm or distress to the individual. We've got some examples of what harassment looks like on social media, because it might be very different to harassment in person. The first example we've got here is trolling. It's quite high profile and well known. A lot of celebrities have dealt with trolling and have talked about it publicly. So the act of trolling is sending menacing or distressing messages and posts about someone on social media. Trolling tends to be sort of one-off events, and the response to a one-off event rather than over a course of time. The second example is doxing. Now, you may be less familiar with this, but it does appear to be on the rise. So doxing tends to be a revenge tactic where, for example, somebody has made a controversial comment on social media. Other people disagree with that comment, and as a result, they go searching through the internet for the person who made the comments' personal information, such as their bank details, medical records, home address, and make those records available on social media to anyone. Sometimes that information is then used by other people for nefarious reasons, and it can have extremely distressing outcomes. The third example of harassment is cyberstalking. So in contrast to trolling and doxing, cyberstalking is defined as harassment which takes place over multiple different platforms over a sustained period of time. So trolling and doxing tend to be more one-off events, whereas cyberstalking may be a combination of trolling, doxing, drop calling people, sending blank emails to people over a sustained period, over various months. It can also mean that they troll people, but over Twitter, Facebook, and Instagram, and it's not limited to one platform. If you have any concerns about being harassed, or if a member of your staff or one of your counsellors is being harassed on social media, then we really recommend that you make a note and keep records of the events and the comments, so that if you do choose to pursue the harasser, that you've got a record of what's happened and clear evidence for the court. I'll pass over now to Amy for a discussion about defamation and malicious communications.
So I'm going to look at malicious communications first of all. So this is a criminal offence that seeks to prohibit the sending of communications, including electronically and via social media, to another person that are offensive, obscene, threatening or false. The Act doesn't include much in the way of a definition as to what would amount to that, but unsurprisingly, we've seen from cases that comments such as racially derogative terms would amount to being grossly offensive. There's a very similar offence in section 127 of the Communications Act 2003, but I'm not going to cover that here in any detail. The intention of the sender, in order to be guilty under this offence, must be to cause distress or anxiety. And the act of publishing or sending and that intention is key. In respect of false information, this must require the sender to know or believe the information to be false, and subject to the circumstances, a false social networking account or website, or the creation of false or an offensive profile or alias could amount to an offence under this Act. If someone's found guilty under the Malicious Communications Act, then they can be punished by an imprisonment term of up to 6 months or a fine. There's been a clear correlation between the increase in reported offences under the Malicious Communications Act and the growth of social media. And it just shows how, unfortunately, some people will use this really useful platform for very unpleasant intentions. Being a criminal offence, there's a higher evidential burden, but also in relation to the fact that there could be a risk to freedom of speech, and there could be challenges in proving an intention. What we've seen is that this is reviewed by the court in the context of whether the content of the communication is such that the person sending it must have intended, or at least must have recognised the risk that that communication would be perceived as being offensive, obscene, threatening or false by someone receiving it. I just want to pause here before we move on to defamation, just to point out that there are some similarities between this criminal offence of malicious communications and malicious falsehood. Malicious falsehood requires there to be a false statement that's made, which is published maliciously, that has caused actual damage to someone or to an organisation. This is a civil action, and we tend to see it most commonly in kind of relation to competitors, that sort of thing. So if one competitor was to release a false statement about another competitor's products, whilst that may not harm their reputation, it may well cause them loss if fewer people then go on to buy that product, and therefore that could give rise to a civil claim for malicious falsehood. I'll now move on to the Defamation Act 2013. You may well be aware, and you've probably heard the terms thrown around in TV and film, especially in America, that there are two species of defamation. Those are libel, which are lasting forms of publication, such as in writing, in print or online, but there's also slander, which are temporary forms, for example, spoken word or gestures. The Act requires a publication to be made in order for there to be a potential claim in defamation. What a publication means is any statement communicated to a third party. There's no need for a commercial publication, i.e. in print, which is a common misunderstanding of the Act. For example, if I was to say something to you today about an individual or a company which was defamatory, then they could pursue me for defamation, even though I haven't put anything in writing or published it in a newspaper, etc. There are various requirements in order to bring a claim in defamation. A claimant must have what we call standing, or the ability to bring a claim, and individuals and incorporated associations and entities do have such standing. Unincorporated associations cannot bring a claim, but individual trustees, employees or volunteers would be able to bring a claim if they can show that the allegedly defamatory statements were made against them or about them personally, not just about the association as a whole. You must be able to show that the statement or publication you're complaining about referred to you as the claimant. This could be by reference to your job title, or it could be by reference to a small group of people if you can show that the statement was intended to relate to all of those individuals. You'd also be required to show that the meaning of the statement was defamatory. And the legal test for this is whether it tends to lower the claimant in the estimation of right-minded members of society generally. That last word is quite important, because if a claimant is part of a group or organisation that may have a higher expectation of morals or behaviour, and therefore something is said about them which would lower the estimation of those specific members of that group about the claimant, but that the wider society wouldn't necessarily think any less of them, it wouldn't damage their reputation more widely, then that wouldn't meet the threshold for a defamatory meaning, as it has to apply to society generally and not just within little pocket groups or specific organisations. Finally, you must show that serious harm has been caused or is likely to be caused as a result of the statement being made. This is what we refer to as the serious harm threshold, and it's in place to avoid trivial comments and allegations being subject to defamatory proceedings. Case law has shown that comments about a housing association and its CEO that they were making money out of the misery of residents was not sufficiently serious to warrant a defamation claim. We'll move on to the first of three defences that are available in response to a claim in defamation. The first is that of truth, which is fairly self-explanatory. The burden's on the defendant to prove the truth of what they've said. This can apply even where the statement made contains a number of allegations and the defendant is only able to prove that some of those are true and not others. The key there would be whether the main elements that are defamatory, or what we refer to as the defamatory sting of the statement, is true. But the less serious or less important accusations may not be true, but that isn't as important for this purpose. The more serious the defamatory meaning, then the harder it is to justify, and the more proof that would be needed that the statement is true. It's important to note that the intention of the person making the statement is irrelevant for the purposes of the truth defence. Therefore, if I was to say something about Neve that was defamatory, which I didn't know whether it was true or false at the time I said it, but at court I could prove that it was in fact true, then I could still rely on the truth defence. The next defence is that of honest opinion. This was previously known as the fair comment defence and was often relied on by the press. In order to rely on the honest opinion defence, you must also be able to indicate within the defamatory statement or the wider context that you have shown your basis of the opinion. The test for this is that you must be able to show that an honest person could have held the same opinion that you did based on the information that was available to you at the time. The third defence is that of public interest. This is important to note that a defendant must reasonably have believed that publication was in the public interest. We often see defendants trying to bring this claim in without any real basis for it, or without really believing it was in the public interest. They just try and bring it in later as a defence in the hope that they could knock out a claim. Some examples of where this defence has been successful were in relation to allegations of incompetence in the management of government-owned companies and the accusation of abusive position of an editor of a scientific journal. Another form of defence is what we refer to as privilege. So some proceedings have absolute privilege, and this are things like court proceedings and parliamentary proceedings, in order to ensure that those processes can go ahead unhindered by any concerns about defamatory statements or defamatory claims being made. This means that anything said in evidence in court cannot be subject to defamatory proceedings, and there have been some examples in the past where a Member of Parliament has relied on this privilege to make statements in the House of Parliament, which they know are going to be widely published. The second limb of privilege is qualified privilege. And it's important to note that this can be defeated by malice. So any publication made, if you are then trying to rely on qualified privilege, must have been made in good faith. There are two forms of qualified privilege. The first is statutory qualified privilege, which are a list of protected disclosures and statements that are included in a schedule to the Defamation Act. This includes a copy, extract or summary of a notice issued by a government or authority performing governmental functions. So that clearly would include local authority and council notices. There is also common law qualified privilege, which is a bit more complicated. This relies on there being a reciprocal relationship of duty and interest between the person making the publication and the person receiving it. This tends to hinge on whether there is a social, moral, or legal duty to share that information and for the recipient to have a legitimate interest in receiving it. So an example would be where the council becomes aware of safeguarding concerns. They may then go on to report that to CQC or to the DBS service. They have a social, moral and legal duty to share that information and those concerns with those other third-party bodies to ensure that the concerns are appropriately recorded, investigations are undertaken and any appropriate action is taken to ensure the safeguarding of those concerns. Similarly, the CQC and DBS would have a social, moral and legal interest in receiving that information in order to act on it.
Sorry to interrupt you there, Amy. We've just had a question in on, I believe, qualified privilege, and it's about if a communication is made under an information sharing protocol, if it then turns out to be incorrect, could that be defamation? Now, I'm assuming depending on the information sharing protocol, it might fall under qualified privilege. Unfortunately, the question doesn't provide your name, but if you've got any further questions, if you want to give myself or Amy an email and set out a bit more information, we'll be able to help you further. But hopefully Amy's quick summary there has answered your question.
Yeah, thank you, Neve. I think this is one that would, as with many issues, unfortunately, would really depend on the facts in hand. But you know, in theory, that could fall within qualified privilege if you could show that interest that was there and the reciprocal duties that were present. And I think just because the information is false doesn't necessarily mean it's defamatory anyway. So it would depend on what's actually being said, what the complaint is, and then how it was shared and why, and there may then be a valid defence to rely on there. As Neve said, if this is a specific situation that you're facing, feel free to drop us an email. We'll be happy to look at it in a bit more detail for you. So I now want to have a look at some specific points to note and examples in the context of local authorities. So in the case of Derbyshire County Council against Times newspapers in 1993, it was established that both central and local government cannot sue for defamation, but they can still be sued for defamation. There was some question when the Localism Act 2011 came in whether this principle still applied, due to the fact that there is a power of general competence to take certain acts. However, Lord McNally has confirmed that that is still the case, and the Localism Act doesn't make a difference in respect of that. As mentioned earlier, that wouldn't prevent individual councillors or employees suing other people for defamatory remarks if they can show it was made against them personally. So this case of Thompson against James and Carmarthenshire Council was in 2013, so it did predate the current Defamation Act, but pretty much all of the principles from this are still applicable under the new Act. So Mrs. Thompson was disgruntled about the outcome of planning decisions made by the council, and this related to applications by her husband and her brother-in-law. She decided to write a blog called Carmarthenshire Planning Problems and More. And this was highly critical of the council and made accusations of corruption, lying, misappropriation of public money, both generally and in relation to specifically named individuals. A third party wrote a critical blog, presumably off the back of Mrs. Thompson's blog, and both that third party and Mrs. Thompson strongly encouraged the council to respond to the accusations that were being made in both blogs. Mr. James was the chief executive, and he decided to respond in a public letter. The letter included comments that Mrs. Thompson had been running a campaign of harassment, intimidation, and defamation against council staff and members. He also mentioned a specific incident at a meeting of the council where the police had to be called. Mrs. Thompson had been trying to record council proceedings, and even though she was repeatedly asked to stop, she wouldn't do so. They then sought to eject her from the meeting, and she caused a bit of a ruckus, and they ended up calling the police because they were worried that the situation would escalate. When the police arrived, Mrs. Thompson made a false statement about a council officer assaulting her, and therefore Mr. James made reference to the fact that she had sought to pervert the course of justice by making a false report to the police in this letter. Mrs. Thompson wasn't very happy about this letter and decided to sue Mr. James and the council on the basis that it was defamation and a breach of her human rights. The council and Mr. James were able to prove that the comments in the letter were in fact true due to her conduct of behaviour towards the council officers and the fact that this had been going on for some time. The court also commented that the qualified privilege defence that we've gone over may well have applied even if the truth defence hadn't, because they determined that the council and or Mr. James had a social, moral or legal duty to address and respond to the accusations that were being publicly made against them. Whilst they mentioned that that may well be successful, we would recommend some caution in publicly responding to and calling out a particularly litigious critic. So we'd suggest getting advice before doing that if you are faced with a similar situation. Mr. James counterclaimed for defamation due to the allegations of corruption, misuse of council funds and lying that she had made against him. And he was actually successful and awarded £25,000. Mrs. Thompson tried to appeal this on a number of grounds, but was unsuccessful, albeit the number of payments that she was to make were reduced in value each month in order to prevent her from having to sell her house. There are other considerations to be had as well in relation to defamation. Most importantly is that of the public purse. This is a notoriously expensive and technical area of law. The case of South Tyneside Council against Ahmed is a reminder of this. This didn't actually get to defamation proceedings, but the council undertook various actions, presumably in order to set it up so that individual councillors or employees might be able to do so. They were heavily criticised for using public money to take various legal actions to try and identify bloggers, including taking action in America against Twitter themselves, to get them to release identity information about the accounts in question. The council was concerned about their duty to the employees in question because of the vile and apparently defamatory remarks being made against them. However, as I've mentioned, the actual intention was quite unclear as to what their ultimate aim was, because the council were unable to issue defamatory proceedings. Nonetheless, that did seem to be the main thrust of the action that they were taking, which seems to be a little unfounded. We do think that there was probably alternative actions that would have been more proportionate and would have seen less critical responses to their actions. And that moves us quite easily on to some examples of other actions and alternatives that are available when you're faced with a situation that may include harassment, may include malicious communications, defamation, or other issues. So firstly, you can approach the social media provider and put in a request to try and have posts removed. You can, in some circumstances, even ask for an account to be closed or to be banned for a period of time. In our experience, social media providers aren't particularly happy to do this, but if you look at the posts that have been made with reference to the terms of use between the social provider and whoever it is that has an account with them, which are general terms available on their website, you can then look at whether those posts are in breach of any of those rules. And we tend to find that if you could show that they're in breach of the rules, then the social media provider are more likely to be willing to remove those posts and engage with you. As Niamh has mentioned earlier, councillors and employees should be aware that they can report any issues or concerns they've got to their local authority. And it may be appropriate to have conversations internally as to whether it's appropriate to block the person in particular who's causing the difficulties. A point to note for in-house solicitors and HR is to make sure that you're providing support to councillors and employees who may be faced with challenging social media content. And this also links in with what Niamh has said earlier about policies and procedures, making sure that there are appropriate support mechanisms in place and checks, and so that people know that they can raise these issues and will be supported appropriately. Finally, if there are issues in relation to harassment, malicious communications, or very clear threats, then obviously feel free to report those straight to the police, and they may be able to take immediate action, or at least to provide some further support and advice about other steps that you can take to try and safeguard your councillors and employees. And then obviously, I haven't put it on the slide, but an alternative action would be to approach your friendly local solicitors to see if there's any other specific examples or procedures that you might be able to follow, or if you want some advice as to what would be the most appropriate step to try and manage an issue in a particular set of circumstances. So I'm going to hand back to Niamh so she can talk you through some specific thoughts in relation to social media and councillors.
Thank you very much, Amy. So, as I'm sure you're aware, the Code of Conduct applies to councillors where they are acting in their capacity as members. However, the application of the Code of Conduct for social media and for other general behaviours, it would be just a good benchmark for everyone who interacts on social media, whether that's an employee of the council, us as the general public, or councillors themselves. The Model Code of Conduct in 2020 announced that they would undertake an annual review because they are conscious that the circumstances are changing around how we live our lives. There's legal advancements, but specifically the advancements in social media and technology are so quick that they want to make sure that the Code of Conduct that they are enforcing on councillors is up to date and fit for purpose. Now, the Code of Conduct applies to communications such as letters and emails, but also specifically the 2020 Code of Conduct refers to communications on social media and makes reference to communications including posts, statements, comments that are made on social media. Under the General Conduct section, the Model Code of Conduct states that all councillors should be respectful. They should be respectful of each other and the public, and that behaviour should be transferred onto social media. However, quite importantly, the Code of Conduct also reminds councillors that they should receive respect in return. And therefore, if members of the public are being abusive or trying to intimidate them or threaten them, then councillors are entitled to stop those conversations or interactions, report the comments or interactions to the local authority, social media provider, the police, but also to come off and take themselves away from the social media. And as Amy said, maybe have those conversations about whether it's appropriate to block certain individuals or prevent their access to a particular page. The general conduct section also refers to bullying and reminds you that bullying can take place in person, but also via social media, and that for actions and comments to be bullying, they don't necessarily have to be face-to-face. So again, it ties in with the respect. You should have respect for each other and the public on social media as well as in person. So if you have any concerns about comments being made and concerns that they could be bullying on social media, to again report them to the local authority so that you can get that support, but also to social media provider so that they can be dealt with and taken off if they are inappropriate. So we'll move on now to some examples of where local authorities have used social media and it maybe hasn't gone too well. We'll try not to name and shame anyone to save your blushes. We'll keep it general. So the first example here is a local authority in Shropshire had to investigate some posts made by their local councillors after they had a heated discussion on Facebook and the social media app Nextdoor. The comments were made in March 2020, and in July it was published that the council had taken action, had investigated the complaint and the comments made, but that no action would be taken against the councillors themselves, as the comments made were made in their personal capacity, and therefore we can assume not subject to the code of conduct. That begs the question, when you make posts on social media, when are you acting in your capacity as a member? So briefly referred to this earlier, but where you are a councillor and you are well known for your role within the community as a representative of the council, then it's a good rule to just assume that your opinions will be taken to be opinions of the council. And therefore, to avoid any confusion, just to specifically state that these opinions are your own, do not reflect the council, and to just make that separation and disassociate yourself from those opinions. Just saves embarrassment for everyone and investigations like what happened in Shropshire. Now, our second example is an example of trolling. As we put at the bottom there, probably harassment and malicious communications, possibly also cyber stalking. So as I'm sure you remember with the tier system that was brought in last year, the northwest area was plunged into tier 3 sooner than the rest of the country and was subject to harsher lockdowns. The local council leader, Councillor Williamson, received such a barrage of abuse on social media that she took the personal decision to then come off social media to safeguard her wellness and her mental health. Abuse ranged from social media messages to emails to people leaving offensive voicemails on her work phone. We've put here that councils need to be aware of their duty of care, the duty of care to employees to make sure that if they are on social media and if they're working on social media as part of their role, that they are aware of those safeguards that you've got in place to protect them. And it also, as we said, social media is increasingly expected amongst everyone, and access to local councils is increasingly expected. Making sure that members are also aware of the safeguards will just help make sure that they are protected too. Now, our final case study where things don't go too well is now the infamous Handforth Parish Council Zoom meeting, which was labelled as the best British comedy in decades, and which I believe had a bit of an update last night, where there was a second parish council meeting, and at one point 3,000 members of the public attended, mostly to mock and to make jokes out of it. But that just shows you how quickly things can go viral, and that viral things on the internet are not always transient and they do stick around. It just highlights the need to be conscious of what you say online little is private when it's put online, and how things are coming across online. Of course, we've all had a good laugh at it, but it is important to keep those things in mind. Now I'll pass over to Amy to give you some nice examples of how social media has worked well.
Thanks, Steve. So I get the fun job. I get to talk about where we've seen councils do a really good job with social media engagement and used it for great things. So the first one is a council in the Northwest who's been engaging with coach operators through LinkedIn, and they've been doing this through marketing efforts to promote tourism to the area. And it means that they're trying to really use LinkedIn and other social media platforms to encourage more people to attend the area and to really bolster their local economy and to support their local businesses such as the coach operators. We've seen quite a few councils who have analysed social media data, albeit in accordance with their data protection obligations, and have used those to identify the main areas where people have been praising the council or issues in the local area, and those areas where there have been common complaints. And this is really useful because it means that they can look at what might be some quick wins, where there is some longer term work required to improve services or improve something that's not working so well, and where they can look at, right, what are we doing really well and how can we try and apply that to other areas, and how can we kind of gauge feedback from our local residents in a much easier and identifiable way. The next one is a little bit old now, but Birmingham Council used WhatsApp to encourage engagement in under 25s in the 2015 elections. And what they did was they asked people to sign up if they were interested, and then they used WhatsApp to send out regular updates and recommendations, ways people could get involved. And this showed a real increase in people in that age bracket who were getting involved and interested in their local area and in politics generally, which was great. More recently, which was last year, Calderdale Council were tweeting live updates about the fire service response to the floods that affected a large number of areas in the country. And this meant that people could see where they were, how far away they were from their own homes, and they knew that help was on the way. Following that, they actually helped to raise more than £1 million for the flood victims via an online campaign. And it just shows how, when everyone pulls together, how useful social media can be for those positive aims. So that's all from us in terms of what we had planned to share with you today. I'd just like to say thank you very much for joining us today. We really hope this has been helpful, and please do feel free to get in touch if you've got any questions, concerns, or anything that we might be able to help. So thank you very much, and I hope you have a good rest of your day.